A pleasant good afternoon to one and all. Not my regular Mondays. I have been on a little break. So I will wait a minute and see if the people are going to be coming on. I got a lot of calls about the show that I'm holding today. I waited patiently. I did not do any public sessions for the past 3 weeks. I was trying not to be critical while the government screening is happening, the formation. You try to give everybody their space to do what they have to do. So I patiently waited. I have spoken to my party. I have expressed my opinion to my leader. And in this edition of the show, I really want to discuss the screening procedure as laid down in our laws and the interpretation that is being given to the screening law or the misuse of the law. Many of our people know much better. Many of our people that are in position doing this understand the law, yet allow the regulations that are there to govern not govern. I have looked at the screening laws of the Netherlands. I also looked at the screening laws of Curaçao. And I'll discuss those two very briefly so I can show some of the serious discrepancies between those laws and also the similarities between those laws. When I am finished, I will also publish this, a screening matrix of what's allowed and what's not allowed, what is done and what is not done. The reason I'm going to do that is so that at the end of this review of the screening process, you all can make up your own mind to see if what's happening versus what should happen is the same, or if it's different. And if it's different, it will be interesting for those that are doing it to explain to the public of Sint Maarten why they are doing it so. Because I do believe, I'm not a lawyer, but I do believe that the law is the law. I am not a judge. I have my interpretation of the law, and so do other people. What I'm about to give you is basically the position of the lawyer Mirto Murray from Curaçao. He wrote this position 8 years ago. Nothing has changed since then, other than the VDSM law was amended in 2023 to add in the commissioners of the central bank. So we'll get to it, but basically the other laws did not change for Sint Maarten. I will not speak about Curaçao and Holland other than what I have. So when we talk about screening, there are various versions of screening in Sint Maarten. The problem here though is that we want to use what we believe is most applicable to get the desired results or to uphold tradition. I need you to listen to those two words very carefully. Tradition and desires. Because that's what's playing a major role right now in the screening process in Sint Maarten. We got to understand this. The way screening works is the way it's laid down in the law. There are two regulations that do that for Sint Maarten. So I will get to them just now, and I'll tell you why I decided to do this talk show today. Last week, in the budget meeting, I believe it was, the formateur came out and he said that he made a public statement that was published in the media, and tutus, the governor made a public statement. And when you read the two public statements, you only smile and you ask yourself, what's really happening here? The formateur says that the public is getting very antsy because the screening part isn't done. His job was twofold. One, that he had to ensure that there was a governing program and a coalition, which he basically did. Coalition of 8, the 2x4. And the second part was the screening of the candidate ministers, but that was that had hit a roadblock because up until this day, the VDSM and the prosecutor general, did not comply by giving their advices. Now, in the meantime, you all heard and read for sure, just like me, that the VDSM had no right or have no right to screen the minister. Because the function of the minister is not a function that carries the screening by VDSM. And that is correct. Because that's what the law says. In the VDSM law, there's also, I think, Article 10, where you can give permission to be screened if you so desire. So the law says the function of a minister is not to be screened. It's not a screenable function. Het is geen vertrouwensfunctie. It's not a trust function. 2, because it's a political function. And don't forget it, it's a political function. And trust and politics don't necessarily go hand in hand. Good governance. But good governance is not necessarily trust. So you don't play by the law alone when you are governing. You play by more factors, external factors, that can impede on your government. But that's for another time. What is important is that we understand what the role of the VDSM is. Because the VDSM does have a role. It does have a role. And that role is laid down in the National Ordinance of 2013, LB 13 of 0042, which is, in fact, the National Ordinance on the integrity of ministers. So on the procedure on how to appoint ministers and minister plenipotentiaries. That's what the law is about, where the VDSM carries a role. And also the law on the integrity of the ministers, the LIM, which was adjusted for the last time on May 30th, 2015. But before we get to all of that, let's understand what's really happening. Like I said, Maarten Murray did a review. And in the Netherlands, because we so often like to compare that we should be doing things like the Netherlands, and we should do this, and we should do that. Okay, let's look at the screening laws of the Netherlands. The Netherlands, there's a handbook for incoming ministers, also known as the Blue Book, that serves as a kind of guideline for the minister and his support. The formateur, listen carefully, the formateur is the one that speaks to the incoming minister to see if he can really handle his task. In 2002, by letter of the then Prime Minister to the Second Chamber, the adjustment of the Blue Book was made on how the conversation should be and what it should entail. It is a conversation between the formateur and the minister-to-be. That's what it is. Then also, there is a candidate minister must report all relevant facts and circumstances that may play a role in his appointment to the formateur. With regards to the appointment of the formateur in the Netherlands, there is no formal assessment of the formateur's sustainability. Is he good? Is he not good? That's not relevant. In the Netherlands, they will appoint somebody they believe can do the job. Not if the king believes it, not if the prosecutor general believes it, not if the VDSM believes it, not if the tax office believes it. That's not relevant. That's not relevant. And it is important that we understand this. Because then others won't be deciding for the people. The people will decide for themselves then. I think that's a democracy. Now, prior to the interview with the formateur, there are 3 fact-finding investigations that will take place at the request of the formateur. Not the governor, not the king. The formateur in the Netherlands will ask for 3 investigations. 1, an investigation will be carried out in the Judicial Documentation Register to determine whether the candidate has been convicted of a criminal offense. 1. With regards to the investigation of the judicial antecedents, the investigation, and I want to stress on this, is limited to completed cases that have led to a criminal conviction, and therefore not to criminal investigations or criminal prosecution of the candidate at the time of interview. Do you all understand? Somebody that's being prosecuted right now, like a Christopher Emmanuel, they said there's an investigation on him. It's not relevant. Even my person that is in Supreme in appeal, they cannot use my conviction against me in the Netherlands. In the Netherlands, I'm able to be a minister. Yeah. Listen carefully, because we need to sometimes agree to disagree with what's really happening. An investigation. B, an investigation by the General Intelligence and Security Service, the AIVD, is carried out to determine whether relevant data about the candidate is available that the AVD has come across in the past. So the intelligence world will see if your name popped up any place in the past. Again, in accordance with the letter of 2002, the AVD investigation only provides information in so far as the service has encountered the candidate in the past for whatever reason, and information of him or her was recorded on that occasion. It can therefore never be ruled out that there are relevant facts and circumstances in this regard with regard to the person concerned that the AVA has not encountered before, and therefore cannot come to light during the investigation. In other words, in the past your name might have come up in a tap someplace. The intelligence services have that. But it's not relevant. It's not relevant to your screening. Cannot come forward. The third thing, and this one here, I need you to listen carefully. Very, very carefully. The investigation into the candidate's tax data by the Tax and Customs Administration. Now, the Tax and Customs Administration gives a general opinion on the tax behavior of the person concerned and mentions any risky aspects from a tax point of view. Moreover, the specific figures relating to the candidate's income and assets remain protected and are therefore not communicated to the formateur. Hereby us, you're asking to know everything about a candidate to give it to people. The privacy laws in Holland protect that. Here, we put every man's business outside. That's what we're doing. The Tax and Customs Administration investigation has limitations and are inherent into the functioning of the tax system. So whatever data they have from your filings, your personal filings, not your spouse, not your businesses, not your children, that will be looked at. That will be used to give an opinion on your tax behavior in the Netherlands. Now, during the conversation, so after those 3 investigations, the formateur now is going to have a conversation with the candidate minister. And he will talk to him about which functions he can have and cannot have, be it ancillary functions, sitting on boards, or whatever. They will have a discussion and they will decide together if the functions are compatible or not. And if the formateur says, you know, you can't be owning a school and you're a minister of education, that's not compatible. I wouldn't do that. But it is up to the formateur to decide what will happen. Now, again, the formateur will ask also what kind of business interests the candidate has. And there they too again will discuss that this does not become a stumbling block for governing. The formateur and the candidate minister. Then in Holland, there it basically comes to an end. There's a medical examination that if the candidate would like to take to see if his stress levels are okay to handle the pressures that might come with that job, then they do so. It's not mandatory, and it cannot have an effect on your screening. If you say, I don't want to take a medical, you're not obligated to by law. Now, at this point in time, whatever was discussed between the formateur and the candidate minister is private and is strictly confidential, and no notes, no announcements of that discussion can be made to the outside world about the content of the interview. Why do I say this? Because here in St. Maarten, it seems that if something was said in there that ain't good and that's a red flag, the minister can't be appointed. It cannot be discussed in the Netherlands. The formateur decides who becomes a minister and who doesn't become a minister. That's crystal clear. Now let's go to Curacao. Because Curacao is a little different. Curacao has much more issues when it comes to screening. In Curacao, so unlike to the Netherlands, Curacao has a legal regulation of the screening process because the Dutch doesn't really have one. They have the Blue Book, and the Blue Book gives some directions to a process to be followed. In October 2012, Curacao passed the Integrity of the Candidate Ministers PB 2012 number 66, the National Ordinance. In there, you have a few things that you have to look at, because the Constitution, because you see these two things differ already. The National Ordinance to become a minister and the Constitution of Curacao. The Constitution of Curacao says, listen, to become a minister, you need three things. You got to be a resident of Curacao, you got to be of the Dutch nationality, and you should not have been excluded of the right to vote. That's it. Now, in the Constitution, to be fair also, Article 86 of the Curaçao's Constitution states that by national decree, you can set more rules. So let's agree that the rules for becoming a minister, screening, are finding their legal basis there, because any national ordinance is part of formal law, and as such, thus applicable in Curaçao. In Curaçao, you hear what I say? In Curaçao's law. Not Netherlands, not St. Maarten. Now, why was this done? They did this so that the democracy of the government could have been kept in balance and kept in check. And in pursuant to Article 2, Paragraph 1 of that national ordinance, so for the screening, at least 6 investigations must take place before a candidate is nominated for appointment as minister. First of all, the candidate must give written permission. These are the following investigations. You have 1, the judicial investigation by the Prosecutor General, the state security by the VDC, so the Veiligheidsdienst Curaçao, the fiscal investigation by the tax office, the medical investigation particularly aimed at substance abuse. Are you using drugs? Yes or no? That is a mandatory examination in Curaçao. Mandatory. Not in the Netherlands, not in St. Maarten. Then there's an investigation into unusual transactions, so like the MOT. So the Fiscal Intelligence Unit, FIU we call it here, they will start seeing if you were doing some strange things, moving big sums of money, maybe involving money laundering, maybe funding terrorism, whatever that they can find there that looks strange. they will bring up. That's mandatory in Curacao also. And then the last one, an investigation by the cabinet formateur. So in Curacao, here, different to, for example, the Netherlands, the cabinet formateur will be screened by two things. There will be a judicial investigation and there will be a state security, so the VDC. In the Netherlands and in Sint Maarten, this is not the case. The formateur is not screened prior to being appointed formateur. Okay, who all asking that, I don't think is too relevant right now, but I think what is relevant is that pursuant to Article 3 of the National Ordinance, the judicial investigation is carried out by the Prosecutor General. And if the cabinet minister, the cabinet formateur is also a minister, they too are subject to that investigation. The latter shall provide information in any form, from the criminal record and the criminal card system of the Judicial Documentation Service relating to the candidate convictions. So the first investigation is, were you convicted, yes or no? And they go through and check all the records that they have. In addition, the Prosecutor General shall provide a statement, and I need you to listen here, indicating whether or not the candidate is or has been a suspect in an ongoing or closed criminal investigation of a crime, unless the interest of the investigation precludes such. So let's say a candidate minister is involved in an investigation with people that are in the mafia. They will not release that because then they'll tip their hand to the mafia people that they're investigating, or to the money launderers, or to the human traffickers. They will not release that, because then they will lose the big fish, because the minister is not the big fish. He might have had dinner with them, he might have this, he might have that. He might not be the one they want really, but he is part of the investigation. They will not release that investigation. That's what this article says. This article is not relevant to Sint Maarten or the Netherlands. I need you to understand that. Open investigations are not relevant in the Netherlands or in Sint Maarten. I just said it just now for the Netherlands. Not relevant. Now, what happens is the second batch of investigations is pursuant to Article 4 of the National Ordinance. The state security investigation is carried out by the head of the Curacao Security Service VDC, who provides information from the files of that service if available, that relates to the candidate in question and that has been collected by the service in order to carry out the statutory task of VDC, who will provide a statement indicating whether or not the candidate is or has been a suspect in an ongoing or closed criminal investigation into a crime. The results of the investigations are shared with the Vice Chairman of the Advisory Council and the Governor. So not with the formateur. It's important to understand this. Not with the formateur, because he too is being screened at this point in time. So he will not see those things. Now, what you need to understand is that if this happens, the formateur can also ask for more investigations to continue. Then they go into a whole tax investigation of the people that goes extremely deep, much deeper than, for example, in Sint Maarten. And they go into family and all those type of things. They go and check the SZV, your behavior and payment with the taxes. And if you were an employer, how did you deal with SZV? Did you pay SZV? Did you do your premiums, etc., etc., etc.? Now, in Curacao, medical examination is mandatory, and it is basically to investigate into the use or abuse of narcotics or intoxicants. Basically, they want to know if you're using drugs. That's what they want to do. That is not applicable in the Netherlands, nor is it applicable in Sint Maarten. I need to make you all understand something, because just now when we spoke about the VDC or the VDSM in Sint Maarten or the AIVD in the Netherlands, they investigate any and everybody that are a threat to the country's safety. So if, let me take me, if I am a threat to the country of Sint Maarten because of who I hang with, who they see me hanging with, they see I traveling every 2 weeks, and I have no work, where you get the money from? What is he doing? Is he transporting information, drugs? What is he doing? To give you an example, that is observations that they are making. They're not factual. They are presumptions that they can make and they should make to prevent something of happening, especially when terrorism is at play. So they will pick up on this information, but to what extent the information is usable is the discussion. That is where the discussion really stands. And depending on what your laws say, is where you can say, okay, I go in here or I go in there. But we need to understand what it really says. So I just wanted to give you an idea, because the VDSM in Sint Maarten has a task that's laid out by law. And they also have an obligation to screen functions. Unfortunately, the function of a minister is not a function to be screened in the law. That's why the uproar with the VDSM. But the VDSM have their task to do. But in Sint Maarten, their task is limited, and I will address that just now. In Curacao, there are still 1 or 2 little things that happens, and that is that the head of the unusual transactions hotline conducts the investigation into unusual transactions of a candidate and will provide the cabinet formateur with such if there's anything relating to the candidate. Again, this is not done in Holland. This is not done in Sint Maarten. You can see the screening law of Curacao is extensive. This is very, very extensive. Maybe to the good, maybe to the bad, but that's not the discussion right now. So, again, in Curacao, the formateur has to be very careful, because while he does all these checks and balances and he gets all this information, if one of these investigations is negative, the cabinet formateur cannot just decide that he is going to appoint or to nominate the minister for the post of minister. What he will normally do is make use of an additional level of screening that they give him, and they ask him then, for example, to check the results of certain things with the council of the advisory board and by the how do you call them? Can't pick up that second one now. The general audit chamber. They can also ask for advice there when it comes to unusual transactions or the taxes if they want some better information. Now, like I said, if somebody has been convicted of a crime in Curacao, if you're, listen carefully, if is a suspect in an ongoing criminal investigation into a crime, whether a company of which he can be regarded as an owner or in which he has obtained a majority shareholding has been granted a moratorium, or in which he has obtained a suspension of payments or has been declared bankrupt, or if he doesn't make arrangements to pay in time to distance the business interest, or if he fails to give up his ancillary positions and ancillary activities, or if he has not made arrangements for the paying of taxes or premiums, or has not complied with such agreements, or has not complied with any of these arrangements in part or in full, or has used drugs, cannot be a minister. Those are the regulations for Curacao, as laid down in the National Ordinance of Curacao. And I want to stress Curacao. and if the formateur brings their name forward, he is liable to be punished. And they can put him in jail. So it shows you that Curacao has a very rigorous, and you can remember some day ago there was a whole uproar because a prosecutor general in the Netherlands, whom works for the Supreme Court, took a decision of 2023 where a former candidate minister in Curacao for the post of Justice Minister was given the right to become a minister because a conviction without a punishment is not a conviction that can be used in Curacao to block you to become a minister. It went to the Supreme Court and the decision was taken right away. Absolutely not. A conviction without a punishment is not a conviction as a conviction with a punishment. And they were correctly separated by the appeals court in Curacao, or the appeals court of all of us. Which means that verdict in Curacao, because it's a verdict, not about what the law says, but what about a conviction without a punishment is versus a conviction with a punishment. So, for example, there was a candidate minister here in St. Maarten that had a conviction without a punishment. He cannot be held and said that his screening, he can't pass it. He will pass the screening with flying colors. It wouldn't surprise me that they throw it in there to create a confusion. But legally, it don't hold water. The only thing the prosecutor general can do in St. Maarten or in Curacao is say, listen, in accordance to my task, I am listing all of the convictions that were there. But can it affect him becoming a minister? Absolutely not. And let's not fool people with this. Let us not create things that are not true. Because we love to create nonsense. And then you confuse people. So let's go to St. Maarten. What does St. Maarten say? Because that's what this show is all about. But I had to, for the past 33 minutes, give you an indication of how it is in the other parts of the kingdom. The same Dutch kingdom that we all won. But we all have different laws. In St. Maarten, the screening also has a legal anchoring of the procedure of screening of ministers. One, you have the national ordinance on the promotion of the integrity of the ministers. That's the LIM, the Landsverordening Integriteitsministers. This is the AB 2010 GT number 22. You have the National Decree Model Written Statement of Ministers based on AB 2011 number 14. And you have the more recent National Decree of the 22nd of May 2013, LB 130042, the decree on the appointment procedure for candidate ministers and candidate minister plenipotentiary. That's the laws that will determine the screening process in St. Maarten. Let me now clear the air on two things. The LIM, so the National Ordinance on the promotion of the integrity, or on the integrity of the ministers, is a law that kicks in after you have been appointed a minister. So it is not something that happens before, it's something that happens afterwards. And it's important that we understand that, because that is where the discussion between the Prime Minister and the minister takes place, not the formateur and the to-be minister. It is extremely important that you understand that difference. Because in Curacao, it was the formateur was talking. And the formateur was deciding. In St. Maarten, all of those parts of the discussion are put differently between the Prime Minister and the minister. So the Landsverordening, the National Ordinance on the Integrity of the Ministers, only happens after the fact, not before. What happens before is the national decree, the guidelines for the national decree of the 22nd of May 2013, LB 130442. Now, I need you all to understand a few things. We, in 2010, when the first government sat, we used, after they were all sworn in, we used the LIM, so the Landsverordening, the National Ordinance on the Integrity of the Ministers, to check them. Checked everybody in October, November, everybody handed in the information, told the Prime Minister, who was then Prime Minister MP Westcott now, this is everything, and they sign off and they're good to go. And who didn't do it, they have the right to go to Parliament and tell Parliament, listen, they won't give me the information, and there are repercussions that can take place. That's it. 2013, we created a guideline to see what we're going to do and check what we're going to check before you become a minister. Now, again, at this point in time, all they can be using is the guidelines. That's it. The guidelines also have a questionnaire. I need you to understand that. This one here, this is the guideline. And in the guideline, this guideline has three things. It has de richtlijnen inzake de onverenigbaarheid van belangen en functies. So basically, where do things bounce up on each other that are wrong? And you then get, before there is an appointment, there are 5 things. You got to hand in your CV. You hand in your CV to the formateur, who will then check what going down. The formateur will check if you have any ancillary functions or other things that might not be right. They would like to know some stuff about your financial position and that of your family members. And they also like to look into you and see what's going on with you. The third thing is that the candidate, in discussion with the formateur, can determine which functions they believe are in contradiction with their position to be a minister, and if they will let it down, and the formateur will deal with that as is. The formateur is also, and you see, this is where it gets very interesting. De formateur is bevoegd over de inzage van de voorgaande beslissingen te nemen, het advies van derden in te winnen, waarbij met name wordt gedacht aan de vicevoorzitter van de Raad van Advies en de voorzitter van de Algemene Rekenkamer. So on all these previous things that they had to do, they can ask on, not the Integrity Chamber, sorry, the General Audit Chamber and the Deputy Chairman of the Council of Advice, because the Chairman of the Council of Advice is the Governor. So the Deputy Chairman of the Council of Advice can be asked information to be reviewed. Then the formateur speaks to the candidate about a possible, if needed, medical examination. But again, not needed formally. De formateur bespreekt met de kandidaat de wenselijkheid. De gouverneur en de formateur then get the reviews, the judicial reviews from the antecedent onderzoek, so the judicial review of the Attorney General and of the VDSM. And these all have to do with what's written in the files. No place does it say here ongoing investigations. No place does it say it. in the Memorie van Toelichting, the explanatory memorandum doesn't say it either. So where did we get it from? Where did we get this from? That we pick it up and we use it? Well, that's not such a difficult question to answer. That happened in 2014. Remember, between 2010 and 2014, Sint Maarten was subjected to lots of integrity investigations. Integrity International, the Whiteman Commission, Ben Whiteman and them, and I think one more. And the government of Sint Maarten agreed that the government entities, the government itself, and some other entities on the island were very corrupt. And as such, when the elections came in 2014, there was a statement made by the then powerhouse MP Theodore Heiliger. If I become the biggest vote getter, I will take up the prime ministership. That sent shockwaves. The Kingdom Council of Ministers immediately instructed the governor of Sint Maarten, the then governor, Dr. Anders Eugene Holiday, that he is to put all ministerial appointments on hold until the required screening that they are going to prepare for this island have been done. And that happened. So what happened was that in 2014, October, I'm coming to that now a minute, by royal decree of the 17th of October 2014, the governor was given instructions in the context of the screening based on the so-called corruption that this island had. The royal decree entered into force on the 22nd of October 2014 and was valid until the elections of Parliament in September 2016. Yet though, please note that the decree only had a duration of 1 year. The 2nd of April 2015, I believe the duration had passed. So it wasn't even valid in 2016. But it doesn't mean to say it wasn't used. Because what happened there was that in that decree, the investigations were as following: a judicial investigation, a tax fact-finding investigation, an investigation into unusual transactions, and any other matters relating to the integrity of the ministers was investigated. This was an investigation for the 2014 elections. Now, the governor was given the powers to draw up a questionnaire to be completed by the ministers. Remember, there was a questionnaire before that existed from 2013 by the National Decree of 2013. And that was a questionnaire carrying, let me see, 1, 2, 3, 4, 5, 6, 7, 8 questions. And you also had to sign an integrity declaration. So those laws were put aside because they were trumped by a kingdom law, kingdom decree, trumps a country decree. So they were put aside. 2014 this was done, but then this expired, which means the country decree becomes law again. But this is where it went wrong, because we did not go back to the country decree. We didn't go back to the decree of the 22nd of May 2013, LB 130442. No, we took a bunch of stuff from the kingdom decree and we're doing as if that's part and parcel of the existing law. But it's not. And all those that say, yeah, but it's tradition, you should feel ashamed. You should be ashamed that you even do that. A lot of things were accepted as law in the past, but today are not law. You don't say, well, it was tradition, let's leave it so. No. You apply the law. It's very important. We apply the law. Because it can be only when it's convenient that we apply the law. We apply the law across the board. Now, again, why do I say these things? I say this to say this. The onlyest laws, the onlyest two laws that run the appointment process of ministers, candidate ministers, is the Landsbesluit of the 22nd of May 2013, LB 13/0442, and when they're appointed, we then go in to the Landsverordening Integriteitsbevordering Ministers, because this kicks in once you're a minister. That's when you're checked on this law, not before. And there's no combination possible, because if there was, then it should have been law. That means it would have been published in the National Gazette and it will be taken up in the overheids.nl lokale wetgeving. You'll be able to find it. It's not there. Maybe I missed it. Maybe I can be corrected by all those that have listened to this today to understand that we got to be clear on what we are saying. I need us to be clear on what's allowed and what's not allowed. I want to take the matrix. I want to close this matrix. Will the formateur, will he be screened to become a formateur? In the Netherlands, no. In Curaçao, yes. Aruba, no. Sint Maarten, no. The judicial onderzoek, so the judicial review, the documentatieregister, so convictions, only convictions are being checked in the judicial review. In Holland, yes. Curaçao, yes. Aruba, yes. Sint Maarten, yes. Are you a suspect in an existing investigation, and are you being tried? In the Netherlands, the answer is no. It's not part of the screening. In Curaçao, the answer is yes. In Aruba, the answer is no. And in Sint Maarten, it's also no. You cannot use somebody being a suspect in an investigation that he cannot become a minister. I want to say that again. Somebody that is a suspect in an ongoing investigation cannot be denied being a minister. Can there be a security review by the state based on existing files? Holland, yes. Curaçao, yes. Sint Maarten, yes. And Aruba, yes. Can you use can you do a very specific state review based on new documents and facts? The answer in Holland is no. In Aruba and Curaçao, the answer is yes, indeed. There is a very serious suspicion of a possible danger to the state's safety. In Sint Maarten, the answer is no. You may not do that. Medical checks. In the Netherlands, it's optional. In Curaçao, it is mandatory, but specifically to check if you're using drugs, yes or no. Aruba and Sint Maarten, it's optional. If you want to do it, you can do it. When it comes to having jobs on the side, nevenfuncties, so you have ancillary functions and jobs. In Holland, it's no. In Curacao, it's no, they don't look at those things. In Aruba, yes, but in overleg with the formateur. And in Sint Maarten, yes, but with the Prime Minister. Because, like I said before, our national ordinance on the promotion of the integrity of ministers only kicks in after the fact. So you don't deal with a formateur on that, you deal with the Prime Minister on that when you are a minister already. Vertrouwelijkheid, screening gegevens. So you're screening information. You got to be confidential with that, especially the formateur. In Holland, you got to be very confidential with it. In Curacao, you got to be confidential, but you can also be punished for it if you do so, if you put it out there. In Aruba, you got to maintain the confidentiality. Sint Maarten, you got to maintain it, but if you share it, you can be punished. So in Curacao and Sint Maarten, it is punishable by law if the screening information is made public by the formateur or by whomever had access to those documents. Does unusual transactions make out part of the screening? In the Netherlands, no. Curacao, yes. Aruba, no. Sint Maarten, no. If your business went bankrupt, is that a reason to be used in screening? In the Netherlands, no. In Curacao, yes. In Aruba, no. And in Sint Maarten, no. And de strafbaarheid voordracht in strijd met regeling. So the punishable, the punishment with the regulations. In the Netherlands, cannot. You can't be held accountable. In Curacao, yes. In Aruba, yes. And in Sint Maarten, no. Now, what have I just said in that matrix? A few things. One, if you owe taxes or not, it's not part of the screening in the sense of if you didn't pay or if you didn't make an arrangement, that they can chop your neck off. Sure, it plays a role, but it can't chop your neck off because it's not part and parcel of our screening to become a minister. Understand that. If you're a suspect in a criminal investigation, in a civil investigation, in whatever it is, you are not subject to not pass the screening. You see, these are the things that we need to understand. All I have seen thus far is that we create a lot of noise, but not that the noise is factual. And the governor has the obligation to sign the national decree so that candidate minister can become a minister, or he's obligated to send it to the Council of Advice in the Netherlands so that they decide. But him saying, if I see a red flag and I sign it, it means you're sending it to Holland, sir. Stop the big talk about what you ain't going to do. Your task is very simple. Your task is you either sign the LB or you send it to Holland for annulment. More than that is not written in the law. And we shouldn't create the impression that the governor is a stumbling block, because he is not a stumbling block. The governor has his role to play, and the formateur has to hold the governor to his role. The advice that the prosecutor general gives, the advice that the AVA, the VDSM gives, the advice that the tax office gives, please note it's advice. None of them have any validity by law in the screening guidelines to determine a person cannot become a minister. That is not the law. And don't let anybody fool you with that. I hope I was able to give you all the needed information so that you yourself can replace and make up your mind and tell your people that you have elected. Stand up for your rights. Stand up for the law, because that's what you were elected to do, to stand up and fight the fight that needs to be fought, to ensure that those people that are to become ministers on the merits of the law and not the desires of others. I wish you all a wonderful weekend, and I'll be back on here soon. Don't worry. I had to do this one today because I believe the information being planted out there was sending us from, yes, tree to tree, side to side, but it wasn't really giving us anything tangible that we could say, hey, this is what the law says. This is what it's all about. So have a wonderful Saturday. Enjoy your Sunday. And blessed week. We talk next week for sure. Take care. Bunks is out.